I'm Drew Stevenson, and this is a lecture for my professional responsibility class about ABA Model Rule 7.2. The ABA calls this communication concerning a lawyer's services, specific rules, but this is the advertising rule. And for my students, keep in mind, this rule was overhauled in 2018. If you're reading an older ethics opinion or using outdated commercial study aids or something like that, they may not reflect the latest provisions of the rule. It was significantly changed in 2018. The current version of the rule is on the ABA's website, and that's what I'm going to talk about here. And that's what you'll be tested on the MPRE. The other thing to keep in mind when you're in practice is that this is an area where the states deviate a lot from one another and from the ABA's model rules. So when you're in practice, always look up what your state's current rules are, and also states change their advertising rules pretty frequently, including the state where I live, Texas. And so look up the advertising rules in your state. A lot of times they will have some pieces of the ABA's rule and then some quirky local rules as well. For my class, you have to learn the ABA rules, and for the MPRE, you have to learn the ABA rules. So let's take a look at 7.2a. Says a lawyer may communicate information regarding the lawyer's services through any media. In the past, they had to amend 7.2 a few times as new technologies were developed. So first they had to say it's okay to advertise on the television and radio and print media, and then they amended it to allow for the internet, and they got tired of trying to keep up with technological advances with smartphones and things like that. And so now basically just there's no form of media where people might advertise that is off limits for a lawyer. So we don't have any media types or platforms where lawyers are not allowed to advertise. Do keep in mind under 7.1, you're not allowed to lie in your advertisements. We have a truth in advertising rule. And we have a separate rule, 7.3, that's about approaching people, offering to represent people directly, individuals, sort of in person or over the phone or things like that. But this is about kind of broadcast or mass media, and all mass media is okay in theory. Okay, B, this is the kind of guts of the rule here. A lawyer shall not compensate, give, or promise anything of value to a person for recommending the lawyer's services, except that a lawyer may, one, and before I talk about this, note, the exceptions are going to be most of the questions on my exam, the basis for most of the questions on my exam and the MPRE, because the exceptions are specific and they're easier to turn into multiple choice questions. So make sure you really learn all the exceptions to 7.2b. But also notice the underlying default rule if none of these exceptions apply. You're not allowed to pay people to recommend people to you. And so if you have an acquaintance who's an emergency room doctor or nurse, and they routinely treat people who have been injured in accidents, you're not allowed to give them a certain amount of money every month, as long as they give patients your business card and say, I know a lawyer, he's really good and he'll take care of you. Nor are you allowed to pay them per client who actually comes in, or a percentage of the fee or something like that. Really watch out for that. And by the way, in Texas, we have very strict rules about this. We call it barratry here. And similarly, if you have a really good friend or relative who's a police officer and is taking victim statements and investigating crimes, you're not allowed to pay them kickbacks or even a monthly amount to pass out your card and tell people, here, I know a good lawyer that you can call and he'll take care of you, and so forth. So generally, this is prohibited unless one of our exceptions apply. Okay, so the first exception is reasonable cost of advertisements and communications that are permitted by the rule. If you want to buy billboard space, buy TV ads, buy radio spots, print ads, you want to have your picture on the back of the phone book, all of that is okay. And you are allowed to pay for that. Facebook ads, Google ads, and so forth. And so you can pay for those. And because the idea is that the platform, the billboard company or Facebook, isn't really recommending you. They're just selling you ad space, but your ad is recommending you, of course. And so we have an express permission to take out advertisements. Please note that for a lot of our legal history, this was not allowed But now it is, the Supreme Court said you can't, that state bars can't restrain or have an absolute prohibit on lawyer advertisement. So you are allowed to advertise that. Two, the usual charges of a legal service plan are not for profit or qualified lawyer referral service. So these are usually groups, companies where the lawyer pays a certain amount to be one of the lawyers that they recommend people to and or connect people to. And please note, I'm not going to spend a lot of time in this video because the comments are kind of tedious about this, but you should read through the comments at least once before the MPRE, because the MPRE in recent years has always had at least one question about these group legal service plans. I want my students to think of it as almost like an HMO, where these are companies where people pay a monthly or annual fee, and then they pay whether they need a lawyer or not. But when they do need a lawyer, they either get a lawyer for free or a lawyer at a discount, or they have a deductible. They pay the first amount of the legal fees, and then the company kicks in or something like that. So I've seen there's companies that market these to gun owners. So if you get in trouble for exercising your Second Amendment rights, and you need to hire a lawyer because for your to defend yourself against lawsuits or criminal charges, they will lawyer you up. Why? Because you've been paying every month or every year. There's employers who offer this through these companies as a benefit to their employees, where the employee has the option of, sometimes they could have it taken out of their pay, and sometimes the employer will contribute to it a little bit, but they're having money taken out of their paycheck every month or annually to pay, so that whenever they need a lawyer for a will or an eviction or an accident or something like that, the company connects them with one of their member lawyers who is paid to be part of this. And again, as you would imagine, there's some very specific comments about this, but these are generally allowed. Three, you can buy a law practice under Rule 1.17. I don't cover this in depth in my course because it's not it's not tested very often on the MPRE. But let's say in this picture, I have the Gorilla Law Firm from Lubbock, Texas. This is David W. Smith, PC. If he decides to retire and wants to sell his firm to you, a recent law school grad, you can buy his firm, buy his book of clients, take over all of his cases. Of course, you're going to have to, on 1.17 says, you have to notify the clients and give them the option to go shop around for another lawyer if they don't want you. But most are just going to continue because he's going to recommend to them that, tell them, I'm selling my firm to this lawyer and I think you're in good hands, and so forth. And then you can continue using that person's name and goodwill and branding that they've built up for their firm. So you can buy a law practice as long as you completely comply with 1.17, and the branding and goodwill that they've established sort of refers people to you in a sort of intangible way, and you're paying for that, and that is allowed. Okay, 4, this is one of the big ones. Refer clients to another lawyer or non-lawyer professional pursuant to an agreement not otherwise prohibited under these rules that provides for the other person to refer clients or customers to the lawyer. So this is a reciprocity agreement that you have with someone. Let's say that you're a litigator and you have a friend who does transactional work and you each have your own firm. Well, so when clients come to you and they need transactional work done, you have an agreement. You'll refer those people to your friend, and your friend will, when they have a litigation client, will send that person to you. That's okay as long as you meet these 2 conditions. Please note, we're not talking about paying kickbacks or money to the person. We're talking about just I'll refer people to you if you refer people to me for your area of specialty. Right. And so, and this could also be that you have a friend who's an IP lawyer and you do trust and estates and wills. And so you don't really do the same sort of legal work. Well, this is okay, but it can't be exclusive. Right. So if at some point you can't have a binding agreement that somehow you'll be subject to sanctions or penalties or have to pay money or be in a breach of contract if you ever refer someone to another lawyer. So it can't be binding and exclusive in that sense, even if in practice you always refer people to that other lawyer or they only refer people to you. There can't be an absolute a strict prohibition about it. And the client, of course, has to be told, hey, I have a deal with this guy, we refer clients to each other, and so forth. So they have to know the existence and nature of the agreement. You can't keep the client in the dark and have them think that they were just sent to you because you're so awesome if you actually have a reciprocity agreement. Okay, 5. This is new in 2018 and a little bit controversial. Give nominal gifts as an expression of appreciation that are neither intended nor reasonably expected to be a form of compensating for recommending a lawyer's services. So if your former professor from law school refers someone to you, let's say, and you're really grateful, can you send that professor a thank you card? Yes. Or if your aunts and uncles are referring clients to you, and or your former employer from before law school is sending clients to you, you can send them a thank you. And in fact, you can send them a little gift, a fruit. I call it the fruit basket rule. You can send them a little gift basket or something like that, saying, thank you for sending me this client. This turned out to be a big case or a big win for me and a big step for my firm. That's nice. What you can't do is go around telling people, hey, if you refer people to me, I reward people for referrals, right? Where it looks like you're paying people, promising really fancy gift baskets for every referral they send. So there can't be any type of expectation or intention that they referred people to you because they thought you were going to make it worth their while. So you can express gratitude, but it has to be sort of a reactive expression of gratitude. Very important. C, a lawyer shall not state or imply that a lawyer is certified as a specialist in a particular field of law unless, and by the way, this was a long-standing rule, but it was under a different number and it was relocated to 7.2C in 2018. 1, you've been certified as a specialist by an organization that has been approved by an appropriate authority of the state or District of Columbia or U.S. territory, or by the ABA, by the American Bar Association, and you put the name of the organization in the communication. So you're not allowed to get together with 3 friends and set up like your own little lawyer ranking system, right? The Golden Globe Awards for lawyers, and really it's just a mutual admiration society. You each give each other an A+ ranking. Trust me, people have thought of this, right? Where you get your law school friends together and you set up this sort of sham referral ranking system that just and the people don't know that basically everybody it's just part of a club who all rank each other as awesome lawyers or first-rate lawyers or A++ lawyers or something like that. In Texas, the state bar has a very elaborate setup with board certifications for several different areas of specialty. And if you are going to say that, you can say you're a specialist, right? You can say I specialize in litigation. But if you're going to say I am a certified specialist, you have to say who's certifying you, and it better be the people who are allowed to certify lawyers in your state and not something that you and your friends made up. Okay, D, any communication made under this rule must include the name and contact information of at least one lawyer or law firm responsible for its content. And so if you're going to have an ad, have a phone number and a name of either the firm or a lawyer. Sometimes ad companies will run these kind of like mysterious ads where it's just like, I don't know, pictures of green cheese or something like that for a while and get all this buzz going because people are like, I don't even know what this is an ad for, but the pictures are so cool or something like that. And then eventually, once everybody's talking about these nifty, mysterious ads, the advertiser will come out and unveil whose product or service that this is really associated with or promoting. Well, you're not allowed to do that as a lawyer. If you're going to run an ad, don't make it cryptic, don't make it mysterious. You need to have contact information for someone. I'm just going to hit a few of the comments that I think are important for answering test questions. Comment 1 says, it's always okay to have your firm's name, address, email address, website, and telephone number in your ad. Those are always allowed. Also, you can say what kind of law you do. Do you do litigation? Do you do criminal work? Do you do immigration work? You can talk about how you do fees. Do you do contingent fees? Do you take things on payment plans? Also, if you want to go ahead and spell out that you'll do name changes for $200, or that you'll handle somebody's adoption for a fixed amount, or a DWI, or an uncontested divorce, and that you accept payment plans and credit card arrangements and so forth, you can put all of that in your ad. You can say if you speak a foreign language. What we mean here is that you will be able to represent someone who doesn't speak English. And in other words, if you went to Italy for a study abroad program, and you took your little Berlitz guide and you know how to order beer and ask for the bathroom in Italy, that does not count as you speaking Italian for purposes of this rule. Right. And so the fact that you know a few words in some foreign language doesn't count. The question is, if a client comes in who doesn't speak English and only speaks that language, will they be able to explain their legal problem to you in a foreign language, and you'll be able to understand it, and you will be able to give them all the information they need about the representation and what their legal options are in their language. Now, if you have one person, and it could even be a support staff, clerical staff, or someone like that, or one lawyer at your firm who can serve as an interpreter for everyone else for Portuguese or Italian or Spanish or something like that, that's okay. You can say your firm can represent people in that language, as long as the person is proficient and will be able to interpret, and you can provide competent representation. Okay, names of references. But if it's a client, it has to be their consent. You have to get consent from them. And sometimes lawyers will do this. Watch out for testimonials. Remember Rule 7.1, you can't set this up in a way where the person talks, where you brag about how much you won for this person and imply that you'll do that for everybody, because everybody's case is different. But if you represent a celebrity, or you represent a well-known corporation, or someone who's very popular, or another firm, or you represented a president of the United States at one of his impeachments or something like that, and you want to put that in your ad, as long as the client consented to you listing that they're some of your well-known clients, that's okay. Any other information that might invite the attention of those seeking legal assistance is generally okay, as long as it's true. Comment 2. You're not permitted to pay others for recommending the lawyer's services generally. And remember, this is going to be any communication that endorses or vouches for a lawyer's credentials, abilities, competence, character, or other professional qualities. So even if it's somebody who's saying, I know this guy and he is so honest, or he is such a sweet person, or doesn't have a mean bone in his body, or really cares about other people, that type of stuff is still a recommendation, even if they're just not taught, or wow, that guy's a really good lawyer, he went to the best schools. Anything that puffs you up to potential clients counts as a recommendation, and generally you're not allowed to pay unless it fits under one of the 5 exceptions, and those are pretty specific. Directory listings and group advertisements that just list lawyers by practice area are not recommendations. So if you're in the phone book under criminal practice lawyers or immigration lawyers, that's not a recommendation. That's okay. Comment 4, I'm skipping to comment 4 here. And this is our fruit basket rule, and this was new, added in 2018. B5 permits lawyers to give nominal gifts as an expression of appreciation to a person for recommending the lawyer's services, or referring a prospective client. And the gift cannot be more than a token item, as might be given for holidays. Now, we're talking about token items that lawyers or professionals give. So not just a Starbucks gift card for one free coffee, but maybe a gift basket like the one pictured here. I don't think you're going to get in trouble for. But a gift is prohibited if it's offered or given in consideration of any promise, agreement, or understanding that a gift would be forthcoming, or that referrals would be made or encouraged in the future. So you're not allowed to go around telling people, by the way, if you ever send me a client, I give good gift baskets. I mean, the one kinds with sausage and cheese, or Godiva chocolates or something like that, not just fruit. And so don't promise them, and don't tell people when you send them a gift and say, thank you for sending a client to me. And by the way, there's more fruit baskets where that one came from, or something like that, that would create an impression that you're basically bribing people to send you clients. Okay, comment 8, except as provided in this rule, a lawyer who receives referrals must not pay anything solely for the referral. And And so the lawyer does not violate paragraph B of this rule by agreeing to refer clients, to another lawyer or non-lawyer professional, as long as it's non-exclusive. As long as it's not exclusive like that. So as we are looking at this rule, the basically the reciprocal agreements are non-exclusive and the client has to be informed. And also keep in mind that conflicts of interest created by such agreements are going to be governed by Rule 1.7. So keep in mind, as I said, with the rule, you can have these reciprocal agreements, but not if you're going to punish the other person if someday they refer someone to someone else, maybe because they think you really don't know a certain area of law, or they have made a new friend or something like that. And you also need to have the freedom to not refer every single person to them, even if in practice you do most of the time. Okay, and so that's, but keep in mind that generally, if you're starting to pay true kickbacks, we're going to have a problem. Okay, that concludes our lecture about ABA Model Rule 7.2 and our advertising rules.